Let's have a look at Article 1 of the Convention. This convention applies to contracts of sale of goods between parties whose places of business are in different states. A. When the states are contracting states, or B. When the rules of private international law lead to the application of the law of a contracting state. Please note in Article 1, it's the place of business rather than nationality that determines the application of the convention. When the parties to the contracts are located in different contracting states, then the convention will govern. If Article 11A is fulfilled, the convention will be applied automatically. The contracting parties don't need to opt in. However, they can choose to opt out of the application of the convention by excluding the convention or changing the application of some articles. This is party autonomy. We will later address the issues of private international law. Let's have some cases to illustrate the application of Article 11A. Article 11A establishes the criterion of internationality. Under this criterion, contracts of a purely domestic nature are not governed by the convention. Please note, the convention is not applicable to sales between parties whose places of business are within different territorial units of a single nation state, such as New South Wales and Victoria in Australia, New York and San Francisco in the United States. Let's take an example. A contract of sale was concluded between a Melbourne-based seller and a New York-based buyer. The contract obliges the seller to deliver goods directly to a Melbourne-based sub-purchaser. It would be governed by the CISG because this is an international sale. Let's take another example. A is a Melbourne-based seller and B is a Sydney-based buyer. A contract of sale of goods was concluded between them. It requires the seller to deliver goods directly to B's sub-purchaser based in New York. This contract would not be governed by the CISG because it's not an international sale. Pursuant to the stipulation of place of business, the actual nationality of each party is irrelevant in the CISG sense. Let me take a fake example to illustrate places of business. A and B are both Australian registered companies. A entered into a contract directly with B's New York branch about the sale of goods. This contract is governed by the CISG because their places of business are in different nation states. Let me take another example. A is a Melbourne-registered company. B is a New York-based company. A entered into a contract directly with B's Sydney-based branch about the sale of goods. This contract is not governed by the CISG because their places of business are in the same nation state, in Australia. Let's look at the issue of private international law before looking at Article 11B. What's private international law? Private international law, also termed conflict of laws, is a body of rules used to resolve legal disputes between private individuals about their cross-border international issues. Different countries have different legal systems. When a dispute is between two parties in different countries, private international law helps a court to determine which country's substantive law will be used to decide the matter. Although it's called international law, it's in fact a body of domestic laws. Each country has its own set of private international law. Private international law is distinguished from public international law. Public international law is the law which governs relationships between nation-states. Although private international law is a domestic body of law, a lot of work has been done by various international bodies to harmonize private international law around the world. The harmonization work tries to minimize the impact of different law on international legal disputes and to promote international trade and commerce. Let's make up a hypothetical example to illustrate private international law. A person from England and a person from Russia signed a contract in Hong Kong to have a transaction. The transaction occurred in Sydney. Let's suppose the English law, Russian law, Hong Kong law, and Australian law may be quite different on the dispute arising from this contract. If they had an agreement concerning choice of law or choice of forum, then the governing law generally would follow the direction of their agreement. But let's suppose they didn't have such an agreement. Let's suppose in Australia, this matter is subject to the law of a nation where the contract was concluded. Then the law in Hong Kong would be the applicable law, because they signed the contract in Hong Kong. According to Russian law, the applicable law is the law of the nation where the transaction occurred. Then Australian law would be the applicable law because the transaction occurred in Australia, in Sydney. Let's suppose in England and Hong Kong, the applicable law may be the law where the plaintiff's or the defendant's place of business is located. Then the English law or Russian law may be applied because of their places of business or in the two nation states. As I mentioned just now, private international law helps a court to decide which nation's substantive law will be applied on this case. Therefore, if the litigation is launched in different jurisdictions, the applicable law and the outcome of the case may be quite different. If you are a party to the contract, you should be very careful in choosing the law or place for settling your disputes. You should try to choose one that is the most favorable for you. Okay, let's come back to see Article 11b. Article 11b of the CISG. When the rules of private international law lead to the application of the law of a contracting state, the convention may also be applicable. Some states have made a reservation on this clause. Following such a reservation, even though the rules of private international law point to the law of a contracting state that adopts the convention, the convention still cannot be applied. There are 7 nations that have made a reservation on this clause. We can pay attention to some key trading nations, such as China, Singapore, and the United States. China is now considering withdrawing its reservation on this clause. Germany follows the reciprocity principle. Germany only applied such a reservation for the countries that have made a declaration on Article 11b, such as China, Singapore, and the US. For the nations that do not have such a reservation, the Germany will not either. Okay, let's have a look at some hypothetical examples regarding private international law in the CISG. A is a China-based seller and B is a UK-based buyer. They entered into a contract of sale of goods in the CISG sense. In the contract, they agreed to have arbitration in Singapore to settle possible disputes, and the applicable law is Singapore law. According to the law of Singapore, the applicable law to the disputes is Chinese law. Then the arbitration tribunal will apply Chinese domestic law and exclude the convention because China has made a reservation on Article 11b. Let me give another hypothetical example. A is an Australian-based seller and B is a UK-based buyer. Australia is a contracting state, but the UK is not. They entered into a contract and agreed that all disputes shall be resolved by arbitration in accordance with the arbitration rules of the Australian Centre for International Commercial Arbitration. Then the Australian law applies, and the convention prevails if there is any inconsistency between the convention and domestic Australian law. What if the party of a contract has multiple places of business? Then we choose the one that has the closest relationship to the contract and its performance. In the context of no place of business, for example, online operation only, we choose a party's place of habitual residence.